Good evening. Welcome to the evening edition of From Day One. We pick up in court.
Thank you. Okay. So the first one was that I was practicing law. That was the first one. That's the show cause that you say I failed to appear for.
No, it was contempt for unauthorized practice of law and preventing defendant Flores from meeting with MIDC attorney prior to his arraignment. That was on the original.
No, I have a picture of the original one. This is why I'm not sure.
Do you have a copy of that show cause in front of you right now or no?
This one.
Would you like to see what she has
But-
here?
I just. So if
Okay,
you don't.
so how do I defend?
Hang on. If you do not have in front of you right now a copy of the first show cause, I'm happy to provide a copy to you.
So how did you arrive at a second show cause?
Because you didn't show up. The second show cause is for failure.
But I wasn't on bond. So both show causes are not in effect because I'm not on bond.
Your Honor, what is the date of the first show cause?
December 20th.
No, the December.
Sorry, that was before the December 20th.
Sorry. You may view this document. This is out of the court file. You may view it and then.
So-
send it back.
Judge Gothier, do I have any other recourse to clarify where I was on that day and the information that I was going off of by your own investigator?
You do. You do. And
Okay,
that is a hearing date. Today, we're going to schedule a hearing date and you can present that evidence at that time.
and how will the hearing affect a trial by jury
As I told you, there is no right to trial by jury.
for a
in
contempt charge?
So I
Oh,
can
so
schedule
this is a perfect, nice little tidy package for everything. I see. Okay,
So I can schedule this for a contempt hearing on Thursday, January 11th at 2 p.m.
I think that would be way too soon for me. Thank you.
Why is that?
I need to get to some of the documentation and follow up with that, state trooper, as well as perhaps a few other people, because I'm guessing, am I supposed to just talk to the prosecutor without the other witnesses that I had in my presence at the same time?
I could schedule this for the afternoon of Thursday, January 25th, then that gives you 3 weeks.
Thank you.
So we'll schedule this for a contempt hearing on both allegations of contempt on Thursday, January 25th at 2 p.m. And do I understand correctly, you do not wish me to appoint an attorney that you want to represent yourself?
And then who makes the decision? You make the total decision then?
Well, no, first you make the decision whether you want to represent yourself. As long
No.
as I'm convinced that you're doing so of your own free
Okay.
choice, that you understand what's going on and that you're not going to be unduly disruptive, then you'll represent yourself.
So what am I allowed to do at the hearing to defend myself appropriately?
You're allowed to present legal arguments. You're allowed to present witnesses to testify under oath,
Okay.
yourself or any other witnesses that you bring with you. If you want to subpoena a witness, if you're representing yourself, you can't issue a subpoena without the court's signature. An attorney can issue a subpoena on their own.
So
If
I
you want
can't
to
subpoena
subpoena
them.
somebody, what you would do is you'd go to the court clerk, they give you the paperwork, you'd fill out the subpoena. They would give it to me to review. And if it looks like it's reasonably, connected or relevant to the case, I would sign the subpoena. And it would be given back to you for you to serve upon the person to compel their appearance.
I did not even get to watch the video that day because I was still on the phone with the trooper. And then people told me after I went up for Christmas that there was maybe a bench warrant, that you had issued a bench warrant. But everybody looked for it online at Vine League and couldn't find any bench warrant. So I was not trying to. I thought that trooper had told you what she told me, that I wasn't on bond, so I couldn't have a show cause.
Okay, well, that's all going to be sorted out at the hearing. Okay, we don't have to sort all that out today.
Well, that's a
Okay.
lot of overnight in being arrested downtown and everything for a misunderstanding that I would like to,
Mr. Richmond, I mean,
okay,
you're
I
not-
get it,
You're not
Judge
fooling-
Gothier, I know what happened,
You're
but
not fooling me. I've got the show cause that you apparently cut up into little strips and wrote.
yeah, but I brought it at 9 o'clock because do you know that that's actually a common law practice? And there are courts that recognize common law, because sovereign people and people who take an oath of office can follow common law.
All right, so the
Not the
contempt hearing
codes
on
and
both
statutes.
matters is scheduled for Thursday, January 25th at 2 p.m. I find that Ms. Bridgman is unequivocally exercising her right to represent herself, that she understands the nature of the charges against her, the maximum penalty, and the rights that she has. I find that although she certainly disagrees with the court procedures and processes, which is her right, that she's not being unduly disruptive to the court's business. So the court's going to recognize Ms. Bridgman's right to represent herself at that hearing.
Can I ask one question? What are the parameters that you're going to decide is practicing law versus helping somebody maintain their unalienable rights? How would I delineate that in defense of myself?
Well, that's a question of, excuse me, that's a question of law that you can research before that day. And I said, I'll entertain legal arguments. The prosecutor will have to prove beyond a reasonable doubt at that hearing that you did in fact practice law on that day. That's where then there's a risk to representing yourself, because an attorney, has access to and better training and researching the case law, interpreting what that is. The Michigan Supreme Court has issued some opinions about what that is. If you're representing yourself, you're going to have to find those on your own and make the argument as you see fit. If you want to hire an attorney, or if you want an appointed attorney, they would be able to fashion those arguments on your behalf. But I'm not going to.
No, I've been
Tell
down
me
that
what
path
those arguments
before, and it never turns out the way they first present themselves to you, that they're going to fight the case. It never turns out that way. So I'm fully cognizant and aware of that, but I wanted to see what your standard was going to be.
It's going to be what the law requires.
But I'm not sure which law you're referring to. So I have to research all the laws to determine what this says that is different than the first show cause.
Yet, Ms. Bridgman, if you want to represent yourself, it's a little bit more work. You're going to have to
I'm not saying it's not more work. It's also not presented in a way that tells me what I'm really being charged with, or that anybody has any proof of what they said here. So that's what okay.
All right, well, that's what we'll.
All right,
sort out those
thank
legal
you.
Arguments, and the prosecutor will present witnesses at that hearing, and you can present witnesses. As I said, if you desire the court's help in compelling the appearance of any witness on your behalf,
Okay.
submit a subpoena to the clerk's office that I would
Right.
review. It'd be the district court office
Okay.
that I would review, and I would issue the subpoena.
So one of the key laws would be that in the state of Michigan, anybody practicing law should have, be a member of the Bar Association. Am I correct?
That is correct.
Now,
Man, you have to figure that out at another time, okay? Now's not time to litigate this case.
Yeah, so I have a range
I
of
get
other
it,
charges.
but I appreciate that this is very big in scope, and Michigan statutes and codes, as he says, he's compelled to follow or must obey the dictates. Okay, I'm very well versed in enough constitutional things, so I have to know what the perception is there. So, thank you, I appreciate
And Ms.
any
Bridgman,
clarification.
I do have to follow with the, any decisions of the Michigan Supreme Court are binding law on the lower courts. There are constitutional system in Michigan. Also, any statutes that were passed by the legislature and signed by the governor are laws that this court and all citizens of the state of Michigan have to follow.
So the procedure that was followed here, I could still take up in another manner, correct?
I'm not sure what you mean by another manner. At the hearing, you can challenge the procedure of it.
I was talking to your investigator. She knew what time I had a court date.
Yes, absolutely. If you want to present that person to come testify about that.
Oh, she's not gonna come testify, I'm sure. She's downstate. She might write something.
Well, that's up to you, what you want to present. If you're going to
Okay.
represent yourself, you have to decide how you want to present your case. But I'm giving you the extra time you've asked for.
So this is a major judicial review. Okay, to decide if anything in our Bill of Rights actually applies to the Michigan code and statutes.
You have all the rights in the Bill of Rights. I recognize all those constitutional rights. of course.
Most of what I talk about actually falls under common law because it's common that anyone could understand it.
All right.
That's why it's called
You
common.
set the hearing date.
Okay.
We'll arraign you on the charges. I'm going to recognize that you are exercising your right to represent yourself and discharge Mr. Villanueva from any further responsibility in the matter. The only other question I have to decide is whether you should be released on your own recognizance, or whether you should be required to post a bond before the next hearing. So I'm going to hear first from the prosecutor and then from you on that question. Ms. Miller?
Your Honor, I would object to a PR bond in this case first because of her failure to appear on December 20th. She had notice of that hearing date as she dropped off the show cause to the court that had the date on it. Further, an underlying case that this was initially filed, she encouraged someone to not appear for their court date or to leave the court before they were arraigned. So I do have concern about her appearance at the next trial, the next date.
All right, Ms. Bridgman, anything you want to tell me with regard to whether I should allow you to be released on your own recognizance before that hearing, or whether
I showed up at 9 a.m., Your Honor, and anybody could have called me if they didn't understand that. I filed a similar document in Mackinac County and they accepted it. Common law is a very acceptable kind of a standard if you know it and you know what you're doing. So maybe there'll be a chance that I can present some of these other avenues, because how does my country tell me to take an oath of office to defend the Constitution, but then I'm held to only codes and statutes of the Michigan legislative body, governor, and perhaps Supreme Court? That's the overarching question here, I think. And I think a lot of people
well, I can
struggle with
recommend the
that.
Schoolhouse Rock video to you about how a bill becomes law and the laws.
Oh, I know how it happens.
Your Honor.
I also know we don't have a lot of
Your Honor.
judicial review.
So
Your Honor,
as
part
a
of
bond
the-
question, any input, Mr. Villanueva?
Yes, I guess I know you just released me as the attorney of record, but I guess in support of the bond on her behalf.
Yes, go ahead.
Yeah, so I like to advise the court that Ms. Bridgman is a resident of the city of Sheboygan. She advised that she's a former social studies teacher. She's presently collecting disability. So she informs me, I'm unaware of the status of if she has an automobile or anything. I'm not aware of any known criminal history for Ms. Bridgman, and she reports that she has no drug or alcohol issues. Granted, there's this allegation of not appearing at a previous hearing, and she was picked up, I believe, within the Sheboygan County for that. And so I advise that Your Honor. Oh, and one last thing, she's a politically active member in the community. She has audited an election previously, so I believe she's more or less, I guess, committed to this area, this local municipality. It seems unlikely that she would go anywhere, and how she would do that. And so, Your Honor, I would ask that you set reasonable bond for her release.
Thank you.
All right, thank you. Well, I don't believe that Ms. Bridgman poses any danger to public safety. I don't think she's a flight risk per se of fleeing from the jurisdiction. However, I do believe that she's a heightened risk of just flat out refusing to appear, as evidenced by the fact that she cut up the previous show cause into little strips and wrote that she wasn't accepting an offer.
Well, they
It wasn't
didn't,
an offer, it was an order
sorry,
to appear.
They didn't
And you
actually
can't have
hand it to
people
me.
just refuse to appear on orders to appear by saying, sorry, I don't want to. So I don't think that release on her own recognizance would be sufficient to secure her appearance. So I'm going to set bond in the contempt matter at $10,000 cash or surety to the full amount. There'll be no special conditions attached to it, however, just the standard conditions, Ms. Bridgman, that you have to make sure that we know. If you change we have to know your address, contact information. You can't violate any laws in the state of Michigan or any political subdivision thereof, and you must appear for all court appearances.
so the whole bond thing keeps me under your jurisdiction, which I wouldn't have come into your court the same way today, except that you put me in jail, so I was forced to.
That's the bond that I've set. So
This is the struggle between keeping my oath to defend the Constitution and adhering.
I've taken a similar oath, and I believe I'm obeying today, Mr. Richmond. So we'll see you on the 25th.
We will look at the case law.
That's what it is. All right, we'll adjourn.
And with that, we will conclude this day here on From Day One in just a moment. We'll head on into the Heidi Ho, and from there, then we'll call it a day here on From Day One. And meantime, I'll see if we have anything quick to play as audio while we go ahead and do that fight.
Sovereign citizens are those who disclaim any authority by the government over them based on their own purported personal sovereignty. The sovereign authority that they're talking about is the authority that governments have to make and enforce laws for their citizenry. The belief that this authority does not apply to them leads to frequent encounters between sovereign citizens and the criminal justice system. During the criminal justice process, from traffic stops through jury trials, sovereigns argue that this ideology is a defense against their prosecution for the crimes they're accused of committing and against the jurisdiction of the courts to preside over their cases at all. Now, there is no universal dogma or manifesto defining the sovereign citizen ideology. Its adherents belong to different groups and subgroups that have varying beliefs about why the laws don't apply to them, and they rely on different legal and historical documents and events as justification for those views. However, there are some common themes that come up again and again in cases involving sovereign citizens, and so in this video I'm going to walk through a few of the most commonly held sovereign citizen beliefs, the arguments that they make in support of those beliefs, and the problems with those arguments. At the end, I'll talk about the consequences of making those arguments in court. So what are these beliefs? Well, let's start with the belief that you don't need a license to drive an automobile on public highways or streets. So sovereign citizens argue that they don't need a license to drive on public roads because they have a fundamental right to interstate travel. And that actually is true. The United States has decided in Supreme Court cases that its citizens do have a fundamental right to interstate travel. And that comes from a 1966 United States Supreme Court case called U.S. versus Guest. Now, what the word interstate travel means is travel between states. So Georgia, for example, can't prevent one of its residents from traveling to California, and vice versa. But what this right does not have anything to do with is the mode of travel. So you have a fundamental right to travel interstate, but you do not have a fundamental right to travel interstate specifically by airplane, car, train, or boat. And your fundamental right to interstate travel has nothing to do with intrastate travel, which is travel within a single state. And states are allowed to pass any law that they see fit in any areas where the federal government has not passed its own laws or otherwise prohibited state action on that area. Now that comes from the 10th Amendment to the United States Constitution, and in Colorado, where I practice, the state legislature has done so in the area of requiring a driver's license by passing a law which mandates that any individuals operating a motor vehicle on public highways and roads in this state have a license. That's set forth in Title 42, Article 2, Part 1 of the Colorado Revised Statutes. It's CRS 422-101. Belief number 2, that American courts are operating under admiralty law. Sovereign citizens argue that courthouses in America operate under admiralty law, which is the law of the sea and international commerce, and that therefore they lack jurisdiction over these individuals. Well, jurisdiction is the power of a court to hear and decide cases involving violations of the substantive criminal law, and to impose punishment upon conviction. Now, their argument is that at some point in the past, it's unclear exactly which point, they have different arguments about this, but their argument is that at some point, popular sovereignty, which is the sovereignty which is vested in citizens of a country rather than a monarch, that sovereignty was abandoned in favor of admiralty law. In support of this, sovereigns point to the fact that many courthouses in America fly a United States flag which has gold fringes on it, which they argue is somehow evidence of maritime jurisdiction. Now, the supreme and superseding law in American courts comes from the United States Constitution and the decisions made by the United States Supreme Court interpreting the Constitution. Other laws passed by Congress in the states are passed under the authority granted to these bodies by the U.S. Constitution. And that has been the case in this country since the Constitution was ratified in 1788. It has never been abandoned. Gold fringes on American flags is a feature that the Army added in 1835 to the American flags that it flies. Other military units and governments also frequently fly flags with that feature as well. It's decoration. There are no cases attributing any kind of legal significance to the fringes on a flag in an American courthouse, and lawsuits filed on this basis have been deemed as frivolous. Belief number 3. There is some distinction between a person's corporate self and their individual self. Sovereign citizens argue that Americans are given a corporate identity when they're born, and that this is a distinct and different identity from their true identity. As evidence for this, they point to the use of all capital letters by hospitals and state agencies when spelling out a person's name on official forms such as birth certificates, driver's license forms, and court documents. They argue that their true flesh and blood identity is different from this because it includes lowercase letters. And when they're prosecuted in court, sovereign citizens argue that the prosecution is being conducted against their corporate identity and not their true individual identity. Now, simply put, the laws in this country do not recognize corporate identities for individual persons. There is a requirement that prosecutors prove the identity of the person they've accused of a crime at trial, but this doesn't require navigating through old birth records and checking the capitalization and font size of someone's name. It's normally just done by simply having a witness point to the person in court and identify them by an article of clothing. So what are the consequences then of making these arguments in court? Well, I've seen a lot of people over the years come in and out of courtrooms and make these arguments, and they're always unsuccessful. And the issue isn't just that these arguments don't work. Criminal courts are an adversarial proceeding. Someone wins and someone loses in every single criminal trial. There are plenty of arguments made in cases in court that don't work. But when people adopt the sovereign citizen view, they make their situation much worse than it would otherwise be. Sovereigns sit in jail, unable to post bond because they won't sign a protection order. They violate court orders and end up getting sanctioned for contempt of court, and they forgo legitimate defenses to their cases in order to spew conspiracy theories that cause the jurors overseeing their trial to roll their eyes and then convict them. Now, nothing that I'm saying is going to matter to the sovereign citizens who are posting articles online and citing to the Magna Carta. But I would appeal to those who have read those articles and are wondering if they should be making an argument about their right to travel at their next speeding ticket hearing. If you want to know what the law actually is, start here. Read the statute that you're charged with and the cases that interpret it. At the end of the day, that's all lawyers really do. It'll show you what the DA has to prove in order to convict you at trial. It'll give you an idea of what your defense might be. And it also happens to be the same book that your judge will be reading, which will get you a lot further than making an issue about your name having lowercase letters in it. My name is Austin Lux. I'm a criminal defense attorney. I practice in Colorado Springs, Colorado, and I want you to know your rights and the law.
Thank you, Austin. We definitely appreciate you. If you happen to be in the Colorado Springs area, definitely give Austin a look up here of Mr. Lux, as he sounds like a very competent lawyer to help you out there in the Colorado Springs, Colorado area, as he quickly digested the arguments of a sovereign citizen. With that, we'll finish our fight and be done for the day here on From Day One. As always, please like, share, and subscribe. Be kind to one another and release the Kraken as we march along this evening and every evening here from Day One. Again, have the best of nights. We'll see you bright and early tomorrow. Enjoy the last couple of fights.